Welcome to the new normal of Truthside TV. I am Nilantha Ilangamuva. The use of economic sanctions has throughout history been an integral component of the foreign policy of most nation states. As a blunt tool of diplomacy, the concept of sanctions has been around at least from the time of the ancient Greeks, when Athens imposed a trade embargo on its neighbour Megara in 432 BC. Since then, there has been a long history of countries blockading their enemies to compel a change in behaviour. The history tells us how sanctions failed. My guest today is Alena Douhan. Alena Douhan is a professor of Department of International Private and European Law, Belarusian State University. She was appointed by the Human Rights Council of the United Nations as the Special Rapporteur on the negative impact of the unilateral coercive measures on the enjoyment of human rights. She took her office on 25th March 2020. She is joining by me from her residence in Minsk, Belarus. Welcome to the show. Alena Douhan, welcome to the new normal of Truthside TV.
It's a pleasure. Thank you.
Recently, you have been appointed as the special UN Special Rapporteur on the negative impact of the unilateral coercive measures on the enjoyment of human rights. What is your role? What do you have to do as the Special Rapporteur?
Well, indeed. First of all, it's necessary to take into account that the mandate of the Special Rapporteur on the negative impact of unilateral coercive measures on human rights is a part of the UN Special Procedures, which exist since 1985 in order to raise awareness of the state's general public and the Human Rights Council on the problems which appear in the sphere of human rights profession, protection in different aspects of human rights as well as in different countries. The mandate of the Special Rapporteur on the negative impact of UCM on human rights has been established only since 2015, so I'm the second Special Rapporteur appointed to this mandate. And it was established as far as states started to impose a lot of unilateral sanctions without or beyond authorization of the UN Security Council. And the countries couldn't find any agreement among themselves how they shall assess these unilateral sanctions. So as a result, we came to the situation when a huge number of countries believed it to be good and normal to impose unilateral sanctions. However, the sanction states naturally insisted that it shalln't be done in any case. And therefore, the role of the mandate is first of all to research what is unilateral coercive measures, then what is the impact of unilateral sanctions on the enjoyment of different categories of human rights, of different categories of population. And naturally, in the same way as other mandates, my mandate is supposed to raise awareness of the problem, because quite often neither states and nor the general public could understand how important the problems are. We used to hear quite often that sanctions are imposed because something bad is happening in the country, and we impose sanctions in order to protect human rights. It all sounds pretty correct for everyone. From the other side, we need to no one usually pays attention to the consequences of unilateral sanctions, which quite often result to the mass extensive violation of human rights, quite often of those whose rights the same sanctions intend to protect. And therefore, naturally, the mandate is not only to do the research and to raise conscience, it works to deal with individual complaints if someone's rights are directly affected by the application of unilateral sanctions. I'm, as a special rapporteur, I'm also supposed to prepare reports for the Human Rights Council and the UN General Assembly to bring to the attention of states, NGOs, and international organizations the conclusions I came to, and to try to propose some solutions in this sphere.
Why do we need sanctions, and what's the difference between the sanctions imposed by the United Nations Security Council and the unilateral sanctions by various countries?
That's one of the very profound questions, I would say. When the UN Charter was signed, and as soon as the United Nations Organization was established, states and, let's say, people were very scared of the international conflicts at that moment. And therefore, they established for the possibility of the United Nations to take certain enforcement measures in the situations which are threatening international peace and security. As a result, Chapter 7 of the UN Charter empowered the UN Security Council with exclusive and extraordinary powers to impose military and non-military enforcement action in the situation when the Council itself will recognize the existence of the threat to peace, breach of peace, or an act of aggression. One of the very important and profound aspects at that moment was that the application of sanctions, even by the UN Security Council, could only take place as an exception from the general rules when the application of enforcement measures have been prohibited. Moreover, the UN Charter directly prohibits regional organizations and states take enforcement actions without authorization of the UN Security Council. However, when we look at the notion of sanctions today, which we can see in the news every day, the majority of sanctions we're hearing of are unilateral sanctions. That means these are sanctions which are imposed without or beyond authorization of the UN Security Council. That basically means that the United Nations didn't authorize states to do it, or didn't authorize regional organizations to do it, and they do it because they think so they have the right to do it. At the same time, from the point of international law, the only authority for application of enforcement measures is the UN Charter, which authorizes UN Security Council to adopt any enforcement measures. There could also be situations, for example, when there is a violation of so-called collective obligations. The International Court of Justice views like these, for example, the cases of genocide or apartheid or mass gross violation of human rights shocking the conscience of mankind. And in these situations, other states may decide by their own to take some sort of countermeasure. In our case, we can call it sanctions against a state which has committed mass gross violation of human rights shocking the conscience of mankind, or genocide or apartheid. But anyway, these cases are very, very exceptional. However, today we can observe that the number of sanctions, the types, methods, means of sanctions are expanding exponentially. And this expansion of sanctions quite often has very little to do with international law. However, they have a very high negative humanitarian impact over the individuals who are targeted, or the general population, or even the people who have not been intended to be targeted, but they finally appear to be sub-targets of the so-called secondary sanctions. So sanctions which are imposed for violation of the primary sanctions regime.
In one of your statements, you have clearly stated that the term of unilateral coercive measures, UCM, is intensively discussed and even more often mentioned. However, the UN Charter does not contain it. And moreover, there is no universal definition of the UCM in international law. So this is the tricky part of this whole discussion about sanctions. If we don't have proper definitions to accept what is sanctions mean or what is the unilateral coercive measures mean, I believe we are in a real soup.
In reality, that's again one of the questions which is still supposed to be responded by the world community and is still supposed to be responded by international law as well. In particular, the UN Charter doesn't contain not only definition of the unilateral coercive measures, it doesn't contain the definition of sanctions as well. Because when the UN Charter speaks about even the UN Security Council, it speaks about enforcement measures in the situation threatening the international peace and security. But the absence of definition, from my perspective, is one of the hugest problems today and one of the very first priorities of the functioning of my mandate. Unilateral sanctions are used today so often and in so many forms that countries which impose unilateral sanctions, they insist that everything what they do is absolutely legal.
Right.
The countries which become the targets of the unilateral sanctions, they say that no unilateral measure can be taken against any other countries. And we face now a very interesting situation. From one side, the Human Rights Council as well as the UN General Assembly has already repeatedly proclaimed unilateral coercive measures as illegal. However, if we look at the practice, there is no document which said that unilateral sanctions are illegal. So finally, we come to the case that, let's say, the very notion of unilateral sanctions is bigger than the notion of unilateral coercive measures. So all unilateral coercive measures are part of the unilateral sanctions, but not all unilateral sanctions constitute unilateral coercive measures. Sometimes states may take certain means of pressure over other states. Basically, if you look at the history of international relations and in the everyday life, every state always tried to influence other states in one way or another. But the states can only do it when they stay within the framework of international law. If they impose the means of pressure, for example, which do not violate any international legal norm, that's absolutely normal. Or when they impose any means of pressure in the course of countermeasures, that's also absolutely legal, they can do it. The problem, however, is that quite a lot of unilateral sanctions we face now violate a very expanded number of international legal norms. And here we need to take into account that we speak not only about human rights norms, although these are violated a lot. We speak about other categories of international legal norms. I could probably cite here an example of Qatar, which tries to base its response to sanctions on international law a lot. It provides a really good example as far as Qatar has already prepared appeals to different international organs, for example, the Universal Postal Union and the International Court of Justice and Committee on Liquidation of Discrimination, as well as the WTO, with the request that sanctions imposed against Qatar violate, for example, the Berne Convention on as concerned the postal correspondence when it applied to the Universal Postal Union, or violates, for example, on the International Convention on Liquidation of All Forms of Discrimination. And as a result, for example, the Universal Postal Union has already decided that these sanctions imposed against Qatar have violated the convention and called to the states imposing these sanctions to stop this violation. In the same way, the International Court of Justice has accepted the case of Qatar for consideration. So the preliminary ruling is already made. And naturally, a very expanded number of norms in the sphere of international economic law, as well as the human rights law, are also violated.
So, what are the negative impact on this on unilateral coercive measures because of we don't have definitions of it? So, in the international law.
That's basically one of the factors, upon my opinion. It's much easier from the point of international law when you have definition, and therefore you can assess whether something corresponds it or doesn't correspond it. But in general, sometimes the development of law is not that fast as the development of real life. And in reality, we face now this situation. Sanctions are expanding a lot nowadays, and well, if I wish, I could make some examples on the contemporary expansion today. For example, we could speak about the new means like, for example, the cyber sanctions, and the COVID-19 demonstrated it very clearly when, for example, the Syrian doctors were unable to use medical professional platform in order to get the knowledge how to treat COVID. Or, for example, Zoom couldn't be used by a huge number of countries for educational or communicational purposes as well. The same concerns, for example, sectoral sanctions or expansion of secondary sanctions and a broad number of other spheres. And in every of these cases, the very first step to settle the situation is to try to find the consensus based on the ground of international law. It's no good to say that these part of countries are always good or correct and the other is always not. The idea is to formulate and specify the international legal norms to understand how to regulate this situation. But naturally, one of the, let's say, severest problems is definitely the impact of unilateral coercive measures over the human rights all around the world.
Do you think the sanctions by United Nations Security Council is effective? It has a positive side of it. Before, let me even go back to the history when even before United Nations established, during the time that we were having League of Nations. Pretty much sure you have remember League of Nations the imposed sanctions against Italy due to their invention in Ethiopia, but that was failed. Like that, in the most recently, what's happening in North Korea is a best example to understand about even the United Nations Security Council sanctions are not effective.
That's true. This question is discussed a lot. I do not want to go very much in depth of the historical perspective and analyze what was the difference between the League of Nations and the UN Security Council, but it's necessary to be aware that the United Nations organization was the very first organization which established the universal system of collective security. The League of Nations had a very limited membership, and therefore, and moreover, the League of Nations didn't prohibit the use of force. So the prohibition to use of force has only been set forth in the UN Charter. The UN security, as concerned, there are, let's say, numerous academic and political and the assessment works as concerned the efficacy of sanctions of the UN Security Council. And unfortunately, if you look at the statistics, quite often they are assessed as not effective or having little effect, and sometimes very, very not frequently they say that they have some effect or significant effect. There are cases like that. But in practice, the UN Security Council used to impose sanctions against states very frequently in 1990s. So this period was even called the decade of sanctions. However, when the UN organs as well as academicians started to analyze the efficacy as well as the humanitarian impact of these sanctions, it has appeared that the efficacy is very low. However, humanitarian impact is enormous. As far as, let's say, when we imagine functioning of every state, people, let's say the ordinary people, the general population, who is theoretically supposed to be protected by the United Nations organizations, what the target which suffers the most because of the imposition of the comprehensive sanctions or economic sanctions by the UN Security Council. And that's why in the year 2000, the UN Secretary General said that the UN shall change the policy and introduce the very idea of targeted countries to protect the population. I won't go here in details, but there are numerous reports prepared by NGOs like Human Rights Watch and Amnesty International, which assess, for example, the humanitarian impact of the UN security sanctions against, for example, Iraq after the Persian Gulf War.
Right.
And it shows that the general population suffered a lot. And that's why if we see now the UN Security Council has changed a lot its policy towards sanctions, it never provides a very broad authorization like everyone who can do something. It usually imposes a very short time limitation. Sometimes it's like a month or 40 days. And it usually prescribes what measures exactly can be taken in the course of one or another operation toward the states. And therefore, it basically demonstrates that even the UN sanctions, which doesn't cause any doubts as concerns its legality, have very high negative humanitarian effect. However, the states today started to impose unilateral sanctions, and I have to admit that its efficacy is not different of the ones which have been imposed by the UN Security Council. Legality is much more dubious, but in practice, the humanitarian effect is enormous because they are imposed much more frequently, and they are imposed in new forms which didn't exist in 1990s when the UN Security Council used a lot of comprehensive
In the meanwhile,
sanctions.
I want to draw your attention to the Carto handbook for the policymakers. I'm pretty much sure you have heard about that book published in the United States, where they have mentions regarding this unilateral sanctions. They simply said, quote, unilateral sanctions simply do not work. There are no examples of the US unilateral economic sanctions changing the basic character or significant policies of a foreign nation. The 35 years economic embargo on Cuba, a tiny country less than 90 miles from our coast, is a monument to the ineffectiveness of unilateral economic sanction as a foreign policy tool. This has been discussed even in the US and other countries. And what UN, the United Nations, as the global body, has to do with this?
First of all, I need to agree that I need to, let's say, confirm that I generally agree with the statement which you have just cited, that the efficacy of sanctions is low, and quite often it's just the unilateral decision to do something. When we speak about Cuba, there are numerous statements of the UN Secretary General, UN General Assembly, which call for United States to stop economic embargo against Cuba because it's absolutely illegal. As we see today, it didn't have any reaction as for now, because let's say the United States is a huge actor, and it's very hard to influence huge actors usually. But in practice, I would like here to come back to the point of international law, which I have already cited. The only possibility to change the situation is to form the international legal norm, which will be realized in and which will be assessed in the similar way, but by all countries all around the world. And then in this case, we would be able to rely to the opinion of the world community. Naturally, let's say if, for example, the United States decides to do it all the time, and what we see now today, the United States is expanding the number of sanctions as well as forms of sanctions, as well as the target of the US sanctions are expanded. Let's say no one can immediately make it to stop. At the same time, if we look at the recent development, we see that the understanding that the unilateral sanctions is not a good tool to deal with in different situations is arising. I would cite here the practice, for example, of the European Union. The European Union used to impose restrictive measures, targeted restrictive measures for a long period of time. But if you look at the practice of the European Union, you will see that it includes lots of humanitarian exceptions in the documents, much more than it was 5 or 10 years ago. The European Court of Justice has already considered more than 250 cases which concerns legality of the restrictive measures imposed by the European Union. And quite often decisions of the European Union organs by imposing these unilateral sanctions have been abolished or annulled by the European Court of Justice because they violate human rights. And it's very picturesque that, for example, 3 years ago, there were only a couple of dozens cases, and more than 200 of cases have been considered by the court within the last 2-3 years. So we see the attention which is paid over here. Again, we could see the new tendencies like, for example, the statements of the European Union as concerned the attempt to impose sanctions, so the US decision to impose sanctions toward the judges and officials of the International Criminal Court, which took place very, very recently. The same concerned the mechanism of establishment, for example, of the in-tax payment system in order to guarantee the possibility of payments to Iran. The same concerned the statements of the European Union states as concerned the sanctions which the United States seeks to impose, or, for example, this Nord Stream program with the oil transit. So I believe that we can't underestimate the United Nations and as well as the power of the world community. Naturally, the situation won't be decided immediately, but that the problem, let's say that the characteristic of international law, it needs time, it needs a lot of attention and a lot of expertise to adapt the existing legal norms to the changing circumstances. And as far as I see, there are already very tiny but steps in the direction of finding consensus.
You were talking about international law, strengthening the international law, finding the definition for the sanctions in terms of international law is very important. But if you go back to the history, there is one case, one judgment the issues by the International Criminal Court of Justice against the US in 1986 for US intervention in Nicaragua, and they said the court clearly ruled out this US has violated the international customary law, but simply US government simply refused it and did nothing. And I'm afraid, but talking about this international law and then the finding definitions and all are beautiful theoretical talks, but when it comes to practical, how can we hold the accountable for the targeted country, for the persons who's responsible for this?
That's the problem you have mentioned does really exist, and we can't avoid it. Huge countries quite often do not follow the rulings of international law. We see this practice, it happens sometimes, unfortunately. At the same time, let's say, we can't expect that the world community will make a huge country to change the behavior in one way or another. However, the positive aspect of international law is that the rules which are useful and necessary for everyone. And one of the examples over here, for let's say, could be cited in the practice of both the United States and the European Union as well. Both the United States and the European Union are imposing unilateral sanctions very frequently. At the same time, every time when there is any attempt to impose unilateral sanctions against citizens or companies of either the United States or the European Union, both of them immediately refer to the illegality of this action from the point of international law. And that's why, let's see, I wouldn't be so pessimistic as concerned the role of international law in regulation of this state of affairs. nothing happens immediately, and I believe a single judgment or a single statement or even a dozen of statements of judges can change situation drastically as concern the unilateral sanctions or application of unilateral sanctions. But if we see the consistent assessment, the decisions, for example, of international organs, now, today, we could only cite, as I said, for example, a couple of hundreds of judgments of the European Court of Justice. The case with participation of Qatar is considered by the International Court of Justice. The case has been considered by the WTO again as well. And altogether, it's adapting the existing norms of international law to the new situation. So nothing will change immediately, and no single person or single organ can change situation immediately. But if there is a public awareness and the governments know what the rules are, the situation will change.
Alena, do you see any double standard when it comes to implementing about these sanctions by those countries?
Well, that's a very complicated question. I'm a lawyer. I'm not a politician over here. And my purpose as the mandate holder is to check how sanctions influence the human rights of the people which are directly affected or which are affected as the population of the country. That's why that's very complicated for me to judge. But as you can see, the numerous political statements, yes, definitely there are statements about the application of double standards. And people have very different idea how the unilateral sanctions work. Even if you look, for example, at the reports which are prepared not only by states, but also by the non-governmental organizations. Someone says we have a violation of human rights in the countries, please apply sanctions to our country. But quite often they do not realize whether there is, or they do not even try to assess whether there is any legal ground for application of these unilateral sanctions. And usually there is no legal ground for doing it. And they do not try to assess what will be the humanitarian impact of unilateral sanctions over the population of these states.
And scholars like you and the specialists on this certain subject and working in the UN, other treaty bodies have kept on saying the injustice about this unilateral the sanctions. And now we have completed 75 years since established the United Nations as well. And some argue, though we are just loud and sounds enough, the UN as the international body is turning into a toothless tiger. What do you have to say about this?
I would disagree with this statement. I believe there was a very famous wording like saying that the rumors about the UN death is very exacerbated. That's not the case, upon my opinion. When we speak about the application of unilateral sanctions on the case, we shall take into account that it's a pretty new development of international law. The United Nations organization has been established on the first hand in order to prevent interstate military conflicts. And if we compare the number of interstate conflicts, it serves its role as well. Naturally, we do not face the ideal situation. Nothing is ideal in our world. At the same time, the United Nations plays its role. From my opinion, one of the negative impacts of unilateral sanctions is when you, let's say, violate international law under the slogan to protect the rule of law, or when you violate human rights under the slogan to protect human rights. It doesn't effective, it doesn't serve its purpose, and moreover, it violates both human rights, the rule of law, and undermines functioning of the United Nations system. And that's why, as I see, the United Nations system and the world community is facing, let's say, in the historical perspective, unilateral sanctions as a pretty new phenomena on the case, which shall be regulated in some way. And as far as both the history and international law do not appear in a moment. You can't expect it will be settled in the moment. But I believe that the role of the that's one of the very first priorities of the United Nations, to find the compromise as concerns application of unilateral sanctions. Because if we look at the humanitarian impact of these unilateral sanctions, quite often is so enormous, and so many people, and here I do not about 1 or 10 or 100 of people, I speak about millions of people affected by unilateral sanctions. It's so enormous that the negative consequences may in some cases be equivalent to those of the military conflicts. I can't agree with the statement which is made by some countries sometimes, because, from my opinion, it has some sort of, moral or political concerns. But quite a lot of targeted countries already seek to equivalate application of unilateral sanctions to genocide or commission of international crimes. And that's why it definitely doesn't improve the international relations, it doesn't enhance the rule of law, they do not improve relations between states or the world economy, and naturally they do not improve human rights because they cause enormous human suffering. You can't protect human rights by violating human rights.
What are the alternatives we have?
From my perspective, I believe the only mechanism is to observe international law. As far as I'm not a politician, as a lawyer, it's very complicated for me to propose the definitely 100% effective alternative. But what I can definitely state is that application of the unilateral sanctions in the existing form is definitely not the alternative. So states shall negotiate with each other to find the way for solution. And quite often, when it comes from the information which I get from different NGOs, and there are statements of the affected population, so people which have not been involved into the governmental activity or any other activity. The main statement of these people is, please withdraw sanction, we will try to rebuild our society by our own.
So we are in a grim situation, so I want to know the brief your assessment about what exactly happening at the moment, and how can we just the answer to this challenging time.
As for today, we need to take into account that the COVID-19 pandemic has exacerbated the situation with human rights in all countries around the world. And as it has happened as a result that countries which are targeted by unilateral sanctions are in the worst situation. In particular, they are unable to buy certain medicine because of the sanctions. Quite a lot of them are suffering because of not being able to buy food or gasoline. They suffer because of the absence of electricity. I could cite here, for example, a couple of cases which will be the most picturesque here on the point. For example, Syria is only able to do 100 tests per day. And when we speak about the pandemic, 100 tests is absolutely nothing. In a similar way, when we speak about the Venezuela is suffering not only from, because not being able to buy some luxury good. Venezuela is suffering because the population does not have sufficient food to eat at least 2 times per day. The population has not only medicine or medical equipment. People are obliged to bring water with them into hospital, not only to drink, but to splash in the toilet. As well as the hospitals in Venezuela do not have even soap, not even mentioning other sorts of disinfectants. And if we look at the recommendations of the World Health Organization, they all say, keep social distance, wash your hands. If you do not have water, you can't wash your hands. Use soap. If you do not have soap, you can do it as well. I do not even mention the situation with millions and millions of migrants who leave countries because of the unilateral sanctions, Well, again, when you look at the statistics of the International Organization for Migration, millions of unregistered Afghans are leaving Iran and come back to Afghanistan after being settled, working and earning money in Iran for 5, 10, sometimes 15 years already. So they are leaving their home places, new home places, because they can't earn their own living. The same situation exists as concerns, for example, the Venezuela citizens which have left the countries and are coming back now. Quite a lot of NGOs as well as the United Nations has criticized Venezuela that the camps where they keep returnees from other countries are very far from sanitary rules as well as good human rights standards. But if the country doesn't have money to buy soup or to deliver water to the hospitals, quite often they're just not able to guarantee normal standards of living and normal standards of care as concern these people. That's why, from my opinion, I'm speaking now aligned with all the statements which have already been done, that the pandemic is a challenge to the world community as such. And the pandemic can be fought only in the course of solidarity, cooperation, and withdrawal or suspension of sanction is very important on this situation, because people do not deserve to die because of pandemic, because they can't get normal medical treatment, water, electricity, gasoline, or soap, or medicine, or medical equipment. And therefore, my recent statement referred, beside that, to another very important aspect, which concerns the efficacy of humanitarian exceptions. It's very good, and I welcomed in my statement every effort of every state and every NGOs who try to deliver humanitarian aid to those who need it. The countries, and here I need to mention, for example, the United States, the European Union, the Russia, China, and number of other countries, they help people a lot, and they shall be prized for it a lot. NGOs which are involved in to deliver humanitarian aid to the targeted countries are also doing a great job to save lives of people. At the same time, humanitarian exceptions are not quite often sufficient, because to deliver the humanitarian aid, for example, the NGO shall get a license to do it, first of all. That's not automatic. That's not so easy. Sometimes it takes lots of time. Moreover, if they try to buy medical staff for delivery, sometimes the payments do not go through the system. For example, when we speak about Venezuela, requests for payment may last up to 1.5 months, or sometimes 2 months. It doesn't go within a couple of days. And people do not get aid they can get. Again, for example, in Syria, when you deliver humanitarian aid, you need to have special permission to use the gasoline at a Syrian gasoline station, because buying the Syrian oil products, it's a problem. It fall under sanctions. So I have received numerous requests from the side of the NGOs involved into humanitarian activity, that quite often they are just unable to fulfill their duties in delivering humanitarian aid to sanctioned state. And quite often they are scared to do it because of the fear of secondary sanctions.
Alena Douhan, thank you so much for joining us, and we wish you all the best for your new post as a Special Rapporteur of UN. And stay safe and well. Thank you so much for joining us. It is an honor to have you on my show.
Thank you very much. It was a pleasure.